Hi, I'm Michael Plowgian, a principal in KPMG's Washington National Tax Office. Today, I will highlight two recent developments that may impact taxpayer-specific rulings from certain governments. These developments are the European Commission state aid investigations and the OECD's action on harmful tax practices as part of its project to combat base erosion and profit shifting, or BEPS. The European Commission has recently launched investigations into whether certain rulings by tax authorities in Luxembourg, Ireland, and the Netherlands comply with state aid restrictions in the European Union. Under EU law, certain types of state aid are not permissible, and selective tax advantages for particular taxpayers may constitute state aid under those rules. The investigations examine whether rulings given to particular taxpayers provide undue advantages to those taxpayers. If a ruling is determined to constitute state aid that is incompatible with EU law, the remedy is for the taxpayer to repay that aid, essentially the taxes that would have been due in the absence of the state aid. And it is a somewhat surprising remedy that has garnered significant attention among taxpayers. It is important to note, though, that we are in the relatively early stages of this inquiry. The rulings under investigation have not been conclusively determined to constitute state aid, nor has the magnitude of the alleged state aid been determined. The taxes in question also appear to be limited to taxes in the jurisdiction that granted the ruling, which may limit the impact in the cases under investigation. This issue is clearly important within the EU, though, and the Commission has indicated that it intends to continue its wider inquiry into tax rulings by EU member states. The second development is the release by the OECD of its report on Action 5 of the BEPS Action Plan. Action 5 deals with harmful tax practices by governments and focuses on substance and transparency in addressing harmful tax regimes. Specifically, the report establishes an obligation on OECD member governments to exchange certain taxpayer-specific rulings with other interested tax authorities. Other interested tax authorities is defined broadly and may include the source jurisdiction, the parent jurisdiction, or the jurisdiction of any affiliated company engaged in the cross-border transaction. The report makes clear that this obligation will phase in two steps. First, beginning this fall, OECD member governments will be obligated to begin exchanging rulings related to regimes that are identified as preferential in the report, if the rulings meet certain enumerated criteria. There are 30 country regimes identified as preferential in the report. None of these relate to US tax law. Second, the report states that the OECD will review ruling regimes in member countries to determine whether a ruling regime is itself a preferential regime that would trigger the obligation to exchange the rulings issued. This work may take some time, but could have a broad impact on the ruling regimes of some countries and on the tax treatment of the relevant transactions in other interested jurisdictions. These two developments may have significant impacts on the ruling practices of some countries and may impact certain existing rulings. Multinationals should stay informed as these initiatives move forward and may want to review their existing arrangements. More information can be found on the KPMG BEPS Insight Network or by talking with a KPMG tax professional. Thank you for watching.